So this is by far one of my favorite books. The author LaRue has not held back when writing some of the things he said in this book. I'm going to start and just read some of the preface and then just go through a few things in this book. So he says, and for insight into human reality of constitutional law, I owe the most to the good citizens of Mississippi, both black and white, who taught me what was at stake. By the time that those in the department and in the Mississippi had finished with me, I knew enough to know that something was wrong with what I had learned at Harvard. Chapter 1, Telling Stories. The title of this book, Constitutional Law as Fiction, summarizes my thesis, which is that the proud towers of the law are built not on the level bedrock of fact, but on the perplexed terrain of fiction, that judicial opinions are filled with stories that purport to be factual but that instead are fictional, and furthermore that these fictions could not be eliminated without crippling the legal enterprise. By the way, I acknowledge the ambiguity of fact, fiction, and story, but in due course hope to explain what I mean by these words. My claim that legal discourse is made of stories that are fictional will strike many as curious, since legal discourse does not obviously resemble the short story or the novel. For example, a judicial opinion customarily cites other cases that seem to be relevant precedents. Novels and short stories do not usually start by citing precedents. The practice of stating an issue or citing a rule are also central to legal argument, but rarely found in novels or short stories. Indeed, the average judicial opinion follows a standard format that differs sharply from that used by novelists. Consider, for example, the typical opinion in a court such as the Supreme Court of the United States. It usually begins with the procedural history, a summary of what has happened in the trial court and the intermediate appellate court, and an event history, a summary of the out of court facts, namely, the events that generated the case or suit. The order in which these two summaries are presented may vary, but they customarily come at the beginning of the opinion. I can illustrate this common pattern by quoting from Everson B. Board of Education, which I shall return to later in order to illustrate the thesis of law as fiction. The opinion begins as follows with events. Procedure second. Mr. Justice Black delivered the opinion of the court. A New Jersey statute authorizes its local school district to make rules and contracts for the transportation of children to and from schools. The appellee, a township board of education, acting pursuant to this statute, authorize reimbursement to parents of money expended by them for the bus transportation of their children on regular buses operated by the public transportation system. Part of this money was for the payment of transportation of some children in the community to Catholic parochial schools. These church schools give their students, in addition to secular education, regular religious instruction conforming to the religious tenets and modes of worship of the Catholic faith. The superintendent of these schools is a Catholic priest. The appellant in this capacity is a district taxpayer, filed suit in a state court challenging the right of the board to reimburse parents of parochial school students. He contended that the statute and the resolution passed pursuant to it by the school board violated both the statute and the federal constitutions. The court held that the legislature was without power to authorize such payments under the state constitution. The New Jersey Court of Errors of Appeals reversed, holding that Neither the statute nor the resolution passed pursuant to it was in conflict with the state constitution or the provisions of the federal constitution in issue. It is also customary for the author of a judicial opinion to state at the beginning of the opinion a summary of the issue presented for decision. Once again, I shall use Justice Black and Everson as an illustration. The only contention here is that the state statute and the resolution, insofar as they authorized reimbursement to parents of children attending parochial schools, violate the federal constitution in these two respects, which to some extent overlap. First, they authorize the state to take by taxation the private property of some and bestow it upon others to be used for their own private purposes. This, it is alleged, violates the Due Process Clause of the 14th Amendment. Second, the statute and the resolution forced inhabitants to pay taxes to help support and maintain schools which are dedicated to and which regularly teach the Catholic faith. This is alleged to be a use of state power to support church schools contrary to the prohibition of the First Amendment, which the 14th Amendment made applicable to the states. In short, judicial opinions do not look like fiction. Their authors do not believe they are writing fiction, and their readers, other judges, lawyers, law professors, and law students, do not normally imagine that they are reading fiction. Instead of describing their work as writing fiction, most judges would say that deciding cases is their primary responsibility. People bring their disputes to court, and if they are unable to negotiate settlements, they submit their disputes to a judge or a judge and jury. As one goes up the judicial ladder, the focus on deciding cases remains, but an additional function, declaring and clarifying the law, becomes important. When we get to the United States Supreme Court in a case like Everson, which I have just cited, the responsibility of declaring law becomes primary. In this book, I limit myself to discussing Supreme Court opinions. Those who declare law have an awesome responsibility, especially when they must declare constitutional law. We expect of them that they expect of themselves caution, care, and meticulous attention to detail. Look back at the two paragraphs I have quoted from Everson. The procedural and event histories are short and incomplete, but also quite specific and concrete in the details. This quality of meticulous care is normally present in other parts of the standard judicial opinion. Precedents are cited and quoted from. With care to get the page numbers right, the issue is stated in a pedantic, almost fussy manner, and in general, the prose of the opinion is normally perceived as dense and technical. Hugo Black's prose differs from that of most judges by being far more colloquial than is customary, and so Black does not illustrate all of my generalizations. However, I wish to argue that one should not be misled by judicial prose into believing that constitutional law is a technical enterprise. Instead, I suggest that one should listen for that moment in legal discourse when a story is told. These moments are crucial. Judicial opinions must be persuasive if the enterprise of judge-made law is to have the power that it has. Lawyers and judges need to believe in what they do. The spirit and self-confidence of the judiciary rest on their belief in the rectitude of their enterprise. Since persuasion is so important, my metaphor, law as fiction, is apt. Without persuasion, law could not be law, and without fiction, there would be no persuasion. And he goes on. This is a really good book. I encourage you all to read it. I'm pretty sure I got this off of Amazon, and there is a copy on archive.org. So this is Constitutional Law as Fiction, Narrative, and the Rhetoric of Authority, L.H. LARUE. in which I use this book in part to make my case that um, judge opinions are based on stories for persuasive purposes.